Okay, folks, we are now on part 2 of Note 2, Law of Business Organizations, Summer Session 2, CCRI, and we have been talking about agency, and we'll continue to talk about agency. A quick review. We talked about a fiduciary being someone who has a legal duty and obligation to work on behalf of another person and to work for the benefit of that person, not for their own benefit, to put the other person's needs and interests first. We talked about an agent being someone who is able to work on behalf of another and actually be able to bind them in contracts and agreements. We talked about principal, which is the person who employs an agent or authorizes an agent to go out and work on their behalf. We talked about employees, and we said that employees are someone who works for another under a high degree of supervision and control. Their hours are regulated, their tasks are regulated, and we talked a little bit about saying that an employee can be an agent and an agent can be called an employee. However, not all employees are agents. The young person on the shipping deck unloading the boxes and equipment as it comes into a large facility does not have the authorization to go out on their own and make contracts on behalf of that company on their employer. So they would be an employee but not an agent. However, a sales representative or a buyer for a company may be an employee of the company, but an employee with agency powers to go out and make agreements and make contracts. And we'll talk about that a little bit more in Notes 3. And then finally, we talked about an independent contractor, which is someone who has a certain skill or knowledge level that they are providing to a party, but they are not an employee. They are not under direct control and supervision. And it is a very important distinction because there are very many laws that apply between employers and employees that do not imply and do not have any kind of meaning between an independent contractor and a person buying their services. And as we get into the Note 3, we'll talk about liabilities and responsibilities and come to see a little bit more how that is critical as to who is responsible for somebody else's activities, because you can be held liable for their damages for their negligence even if you didn't do them themselves, if they were your agent or they were your employee. If they were an independent contractor, they remain solely responsible for any injury or damage that they do. Okay, having talked about that, we're now going to move into how is an agency relationship formed. The most basic way to form them is by consent, where the principal requests and asks that the agent perform services on the principal's behalf, where the principal gives the agent the power to make agreements to bind contracts on the principal's behalf. This can be written. It would be preferable if it is written. But very often, many times, particularly in the older days, it was not. It was a verbal agreement that you will come to work for me and be able to go out and make contracts and do this or whatever. This was a very important concept if you went back over 100 years ago, before the advent of the telephone or telegraph, and before the advent of quick communications. In order for business people and for corporations to be able to sell their goods and services, be able to promote their goods and services throughout the country when there was no mass communications, meant that they were very often sending people out to faraway places where it would take days and days to get to, and it would take days and days to get information back from there. And they would send these people out with the authorization that if you can go and sell the product, if you can make contracts, then please God do that for us, and then circle back here in a month or two with all your contracts and all the orders that you've put in so that we can begin processing them. So this type of situation still exists today, but would be mostly handled by phone and email and by quicker correspondence than they had in days gone by. But you can see how in the old days there would be a need. If you wanted to get your product sold outside of your local village or city or town, you'd have to be able to have people going out promoting it and attempting to sell it and making the agreements, taking the orders and bringing them back to you. An agency has to be consensual. You cannot become an agent by accident. You cannot become a principal by accident. It has to be for a legal purpose. So if you send somebody out to make drug deals for cocaine, that is not considered an agency because the purpose of the agency is not legal. The agreement, the consent, can be express or it can be implied. Now here, express does not mean quick. Express, we are using that term in the legal sense, which means that it is verbalized either by voice or by writing, but that somehow we have spoken about, we have discussed, we have put into words this agreement. An implied agreement is one where we maybe did not speak about it, but through our actions, through our behaviors, through our sometimes lack of actions, an agreement arises. When we start talking about implied agency, we'll see how this comes into play, where sometimes a principal or a person, business person, company, doesn't intend to create an agency, but by putting people in a certain position, letting them use stationery, letting them use telephone lines, letting them use equipment, they make it look to the world as if that person is an agent, and sometimes the law will say that, at least as to a third party, we're going to imply an agency here. We're going to say that one existed, even though the principal wasn't thinking about that and didn't intend it. We will go into that further when we get into the notes on 3. One of the things that happens in agencies is that the principal will give the agent certain instructions. You're allowed to do this, you're allowed to do that, you can't do this, you can't do that. If the agent exceeds their authority, does something beyond what they were empowered to do by the principal, then the principal has the right to reject that in certain circumstances. However, if it turns out that what the agent was doing turned out to be a good deal, something the principal liked, then the principal can do something called ratification. So after the fact, the principal can adopt the agent's actions and say, oh, I didn't give you the authority to work on that deal, but it worked out so well, I'm going to go through with it. I'm going to accept it. So just know that that's there, and we'll talk about that a little bit later also. Something called estoppel comes into play here. Now, estoppel is a kind of strange legal concept, and it's basically the idea that you will not be allowed to testify against something or bring evidence in against something. And that seems very contradictory to our legal system, as the main purpose of courts and of hearings and of testimony seems to be to get all the facts out, to get everything in front of the judge or the jury or the trier of fact, to get everything on the table. However, there are situations where, again, particularly when dealing with third parties, the actions of individuals may create a situation where a third party believes one thing is happening when, in fact, the agent and the principal didn't intend for that to happen. Depending on how serious the activities are and how much of an impression they created in the third party that there was an agency relationship going on, when it comes time to claim by the principal that, oh no, there was no agency here, I didn't give that person the authority to do this, they may be stopped from claiming that. They may be prevented from bringing in evidence to supposedly show there was no agency if the evidence from the third party is strong enough to show that every reasonable person in the world would have thought an agency existed here and that I was operating with this agent with who had the full authority of the principal. Okay, another term that comes into play here is the idea of operation of law. Operation of law means that legal rights are changed. Legal rights are ended or come into being without the parties having to do anything in particular, without the parties intending for that to happen, sometimes without the parties even knowing that that happened. In property law, in wills and estates, when a person dies with their name on a piece of property as a sole owner, that property immediately becomes the property of their heirs at law, subject only to someone showing up with a will saying, oh no, they had a will that said they wanted to do something different. But if no will appears and is probated, then the property immediately upon the death of the owner, it descends to his heirs at law, who, if the person has no children or nieces, direct nieces or nephews, could be cousins, third cousins, fourth cousins, could be people who don't even know that this person exists or that this person owned this piece of property. But by virtue of dying, certain rights have changed, exchanged, moved, and operation of law says they become immediately effective. So sometimes when we're doing a title examination, if somebody has died without having done anything with the property during their life, we have to do a genealogy to find out, well, who actually owns this property now? And sometimes we end up going to people and saying, hi, you have a certain interest in this property, and they did not even know it. The same thing can happen here. With certain types of agencies, they can be implied, they can be imputed, and that can happen by operation of law because of the actions of the parties without them intending or even knowing that they have created a principal-agent relationship. Agencies can be formed again by agreement, either express or implied, in writing or verbally. They can be formed by operation of law through the action of the parties. They can be formed through estoppel. The principal knows somebody is roaming around acting and saying that I'm the agent of so-and-so and does nothing to prevent that person from making those statements, doesn't notify the parties that, oh no, that's not really my agent. That's a type of situation. If a third party relies on this appearance of the agency, the principal might be stopped from denying it. And again, that's particularly in a situation if we can prove the principal knew this person was roaming around claiming to be an agent when they really weren't. If that has affected the rights of third parties, the principal could be stuck being a principal when they didn't intend to be. Agencies can be created again by operations of law. The court can impose an agency to prevent injustice. Right? Now, once an agency relationship exists, each side has certain duties, each side has certain rights and obligations. The duties of an agent to the principal. Number one is to perform, to do whatever job, to do whatever activity, to make whatever sales, whatever contracts the principal has authorized you to do. Number two is called notification. The agent has a duty to tell anything and everything that they've learned to the principal, to give them all facts and all information so that the principal knows what's going on. The agent has a duty of loyalty, which includes the idea of confidentiality. So the agent is supposed to be working not for the agent's benefit, but for the principal's benefit, and the information that the agent is given from the principal and told to keep it confidential must be kept confidential, and certain information that the agent may pick up in their travels, in their work, might be deemed to be confidential and should be disclosed only to the principal and not to other third parties. The agent has a duty of obedience, so that if the principal says go and do this or don't do this, the agent is supposed to comply. And then finally, the agent has a duty of accounting. They must account for all documents, all contracts, all agreements entered into. They must account for any monies expended or any debts incurred, charges incurred, and they must give full information about that to the principal, or they would be under common law in violation of the duties that they took on when they agreed to become an agent. The duties of the principal to the agent are, number one, compensation. An agent is deemed to be an employee in the sense that they have a right to be paid for their services according to whatever agreement there was with the principal. They have a duty of reimbursement if the agent ends up spending things in the course of conducting the business of the principal, incurring expenses, plane tickets, meal expenses, photocopy expenses. The list could go on and on. The principal has a duty to reimburse the agent. If the agent is sued because of something that was done for the principal, solely for the benefit of the principal, under the direction and orders of the principal, the principal has a duty of what's called indemnification. Indemnification means that you will pay for the suits against another. All right? The principal has a duty of cooperation. So if they send an agent out to do something, they can't just say, well, that's it, I'm not thinking or worrying about that. Again, don't call me, don't come and ask me questions, don't ask to consult with me. By creating the agency, the principal has the duty to cooperate with the agent, and the principal has the duty to be concerned of the safety of the conditions into which they are sending the agent or putting the agent, and that they have an obligation not to send the agent or to have the agent do anything that the principal knows could be dangerous, could be illegal, could be threatening to the agent. Along with duties come rights and remedies. All right? An agent has the right and remedy to, number one, tort liability. They can sue the principal for negligence damages. They have the right to sue in contract if they are not paid for their services. They have the right to recover from the principal for failing to pay. They have a right to an accounting from the principal, particularly if they were working on commissions where their salary, their remuneration is based upon how much they sold and what happened with the contracts. Were they carried out or not carried out on behalf of the principal? Did the principal make any money on them? So in those situations, the agent has a right of accounting from the principal to make sure that they are being reimbursed and compensated according to the terms of their agreement. Principals have a constructive trust over all profits and gains by the agent in terms of anything that is made from a deal that was entered into on behalf of the principal. So if an agent goes to a third party and says, well, I'll agree to sell these goods from my principal at X and discount them 10%, but you have to then give back to me half of that 10% discount. If the principal discovered that, the principal has basically a constructive trust over that money that was kicked back to the agent. The agent has no right, without the absolute knowledge of the principal, to enter into any deal that will on the side benefit the agent while not benefiting the principal. Avoidance. If the agent acts outside the scope of the agent's authority, if they go beyond the limits of what they were allowed to do, the principal has the power to avoid any contract or agreement, which means basically to renege on it, to terminate it and stop it. The principal has a right to indemnification. So if the agent does something that causes the principal to be sued, particularly if it's something outside the scope of the agent's authority or ability, then there are situations where the principal can sue the agent for recovery of the loss that the principal suffered by the agent's activities. Okay, I'm going to stop now. This ends my discussion on Notes 2. We will resume with Notes 3, which continued to discuss principal and agency.